my big takeaway is if they can do that in 2, why the hell can't we do that in other divisions?
Yeah, I feel like I looked over and your mouth was a gate because it was like,
Well, the first time
my
she
gosh.
said September something, I was like, wait, what was that?
Yeah.
September?
All right, welcome to the Judgmental podcast. Today we are going to do the viral clip, and then we are also going to break down us going to Motion Hour in Louisville, Kentucky. Yesterday, August 18th, we watched 5 divisions. Really started off well and then quickly went downhill, but we will get into that. Let's jump right into the viral clip.
All right.
Excuse me, the lady. Excuse me, you come forward. Yes, come. No. Come forward. First of all, why are you in this court in shorts?
I'm sorry, I was just, I don't know. I've never really been in court.
All right. Second of all, turn your phone over to the deputy. Do not close it. Deputy Laura, if you'll delete whatever photo she took, please. All right. Who are you taking photos of?
Oh, I was just letting my daughter know my son's okay and that he.
No, my question is, who are you taking photos of? All right. So, Deputy Laura, if you put her in cuffs, since you want to be next to her son and put her in the box.
I apologize, ma'am.
I appreciate your apology.
I didn't know.
Oh, my.
All right. Put your son's picture up. And who is Rick in the box?
He's with Charles Monk.
All right. Well, I'm sure Charles Monk will come back and take care of you. But for now, you're going to be in the box.
Wow. Whoa.
Yeah, that's the second time that we have watched this judge. And last time we talked about how performative, but way out of line.
Yeah, what? I mean, so it appears that someone, the mother of a defendant, was it?
Yeah.
Someone who was in custody that was in the courtroom and apparently took a picture of her son in the court and was arrested for it. And the deputy was ordered to, or told by asked by the judge to take her phone and delete the picture.
Well, first off, too, and that's a search and seizure, no doubt. I mean, absolutely. Took her phone and then said delete something, keep it open, which we all know that there's case law that if your phone is locked, they need a warrant to get into it, right? I can't think of the case on that. But also just what she was wearing, she looks completely fine.
Well, yeah, I mean, you don't arrest someone for that, so I don't think that was, she made a comment about her being in shorts. I have kind of mixed feelings about that. I think sometimes it gets a little bit too casual in court, but that woman didn't look like she was disrespectful whatsoever in what she was wearing.
And they weren't booty shorts. I mean,
No.
and also that's in Texas, but there's something wrong with that judge in Texas. I mean, she's just doing it for the gram. Yep. I mean, I just did not think that was, in Texas, by any means, I didn't think that was inappropriate.
No, and I mean, I think a lot would depend on how they have it posted when you enter the courtroom or whether there's a sign posted inside that you can't take pictures. I don't think that is obvious to people unless it's posted conspicuously and they've seen it. Someone picking their phone up and taking pictures it's so common. People snap pictures of things all the time. God knows, I mean, people photograph every meal that they take. So I think there's nothing out of the ordinary about that. I mean, if it was clearly marked or the court was opened, with a admonishment that you do not take pictures, you don't take any recordings, I think I feel a little bit different about it, but hard to tell.
Yeah, I mean, the irony, though, of the fact that the judge is literally in real time recording and being like, no, little girl, don't you dare take a picture of your son. I mean, I'm not saying it's appropriate, but the search, seizure, destruction of a photo, and then subsequent arrest is just beyond.
No, I agree. And when she called her up there and asked her a question, it seemed like it escalated really quickly for no reason.
Yep.
I mean, you can see someone being belligerent to the court and then them having to hold the person in contempt and lock them up. That didn't happen there.
She was very apologetic. I'm sorry, Your Honor. I'm sorry, Your Honor.
Yeah. I mean, she said, I'm sorry. And then she gets locked up. It was performative.
I really want to talk to an attorney out that practices in front of her because this judge is clearly, like I said, doing it for the gram. I want to know how their dockets are handled. Can you imagine sitting there and just knowing that your client that's paying you could be subject to her just like social media fodder? Is that the right word?
Yeah, but I mean, that's what we have. That's the standard that our court administrator has set in Jefferson County. So that is what we do. It is perfectly fine, according to our court administrator, for someone to be selectively streaming to TikTok or to some other social media from their court while they're taking care of court business.
Yep, and this is McKay Chauvin, who basically said that a judge can record in court for whatever purpose.
Didn't basically say it. He straight up said it.
True.
Said there was no problem. He had no issue whatsoever, were his words, about judges filming and for whatever purposes they want.
Mm-hmm.
Yeah.
Which I would love for them to live stream court. So maybe we can have them do that. And two, McKay Chauvin, obviously open invite to be on the podcast at any time. We did not run into him on Monday, but yesterday we went down and watched 5 divisions for Motion Hour. And I will just start by saying I was a little dramatic, anxious-ridden baby yesterday.
Huh. Yeah, you said that, and I felt the exact opposite. Every time I go over there now, it just confirms how miserable it was to be going through that slog each and every week.
Totes.
And it was so much more fun just being there without anything at stake, without having to make arguments, without having to see if the other side showed up, figure out, constantly check your email to see if someone has filed a last-second objection or asked for something to be called. And you never know what the court's going to do. I do not miss that one bit.
No. I did this weird thing where, like, in the morning I texted you just like, and I was just kind of hoping that you were going to be like a little kid that, like, doesn't want to go to school. And you were going to be like, are we really doing this today? Like, can we get out of this? I don't know why I was so anxious. I guess because we really, for whatever reason, not on purpose, we just haven't watched a lot of 1, 2, or 3.
No. And we've been covering, we go over there for other reasons. We go over there to get things that's usually in the afternoon. It's sort of in the schedule of how we produce things here, and we need to be watching all of them equally, I think.
Yes, I agree. And I will tell you, you said this yesterday, you were spot on. The second Judge Angela Johnson started talking, all that anxiety went away. I was just like, okay, there's not going to be some radical calling us out. She was really, I thought the day started surprisingly well.
Yeah, and I remember that from practicing. I don't know. I always, if I had something in one and you're just starting Sunday evening, you start just dreading Mondays if you have a lot of motion on. In Jefferson County, we have Motion Hour all day on Monday, basically, in family court, and I guess in circuit court as well. It's going on everywhere. But she usually starts things off with an attitude, 1 and 2, just this positive. You could be arguing the most horrible thing, but it was an easy division to be in. It was serious, but more lighthearted than most other divisions, and usually coming out of those, I felt the same way. You sit down in her court and
and relatively
not
competent. There wasn't anything that struck me as far as from her that I was like, oh, hell no, I can't believe you did that. I can't believe you said that. Like, not at all, to give her accolades.
No. The thing that stood out to me was, and I guess I didn't pay attention to it as much when I was in there and arguing motions, and I would leave the division right after, to see how she handled pro se litigants, the dignity and the way that she spoke to them. That was, I thought that was great.
She has a little bit of an air of funny sarcasm, and I don't mean that in a condescending way where you can relate to her as a human. She's no nonsense, but very much is like, we're not going to go off track kind of thing. No. There was that one case that was like super fascinating. Like procedurally, I thought she did great as far as docket management and handling the docket. There was a case, just the standard it seems to be nowadays, allegations of domestic violence, allegations of parental coaching, and then there was that forensic interview, which I thought was so bizarre.
Yeah, I want to follow that. I want to see how that turns out. There were just that didn't make sense.
And there's so many cases now where you have all of these. If you ever have an allegation of domestic violence, then on the flip side of that, there's going to be the allegation of parental alienation. And then you have all these quote unquote experts getting involved and forensic interviews, custodial evaluator interviews, therapy interviews, FOCs. There was an FOC on the case. And that was a little interesting.
Yeah.
So we had a common theme while we were there. I guess, is it okay to talk about this?
Yeah, absolutely.
And so for people that don't know, actually Hugh created, it's case law. It's a fabulous case. It was his firm, and he was the attorney that appealed Brian Gatewood, and we got this case called Adair versus Emberton. We do not have time to go into it today, although it is extremely important, and we promise to do a full, in-depth, probably will be an hour-long breakdown. Because if you're in family court and you've got kids, you need to know this case, right?
Absolutely.
And he is an expert as far as this goes, but my little short quip of it basically is just that an FOC can't speak unless they filed a report. Am I wrong?
I mean, they are tasked as a fact witness to do an investigation regarding some aspect of best interest of the child, some aspect of the case. And the rules say for them, before a proceeding before the court, they have to file a report. They have to get that report and their notes or give access to all of their notes and their processes 10 days prior to the proceeding.
And so the FOC, of course, this judge immediately goes to her, the FOC, and is like, well, what's your opinion? And she did something that at the time, you and I looked at each other and we were like, oh, they're watching our podcast. But then it became a common theme. She was like, well, they're not, I'm an FOC judge and I don't want to waive Emberton. That was the verbiage, right?
Or unless they want to waive Emberton,
Yeah.
I can't say anything. And I think the reason, my opinion, because the Emberton case was very egregious in what the judge did, but I don't think it was uncommon. I didn't believe it to be legally novel, but I think they were getting fed up with the practice of courts just asking friend of court, leaning on them for advice and asking what they should do. Yeah. And it's one thing where you take your court appointment and you do your investigation, you file your report, and you get cross-examined at a hearing. That's the way the process is supposed to work. You're not supposed to just show up, have an opinion, have your opinion rubber stamped, and talk to the court as a person, not ever be sworn in. I mean, there were so many issues with that were addressed in Emberton, and it was just sort of long-standing practice that I think the Court of Appeals was getting sick of.
And it was common practice in Louisville. Again, the case you had was just this judge in particular is egregious with courtroom demeanor. But what was a little weird is basically what the friend of the court said, too, was like, well, counsel, you can say what I said to you. And I'm just like, oh, my goodness. I mean, this is hearsay, but counsel basically just said, well, the FOC feels da-da-da-da-da-da-da, super inappropriate. The judge allowed it. They're trying to figure out ways to get around filing the report. Definitely a case to follow. Forensic interviews, too, are done, well, like immediately after if there's allegations of like SA or, typically I think SA or physical abuse.
You say immediately after. I almost never see it immediately after.
Well, it would be immediately in time from the report to the professional, as opposed to if you were in family court, they would allow the child to leave. And so a forensic interview, in order to be accurate, typically is going to be done like in immediate. If you report it to a trooper, you're going to be taken to whatever agency in that county does it. My understanding from speaking with psychologists is that forensic interviews are the most reliable. Now, I don't have an expertise in that, but that's just my understanding. Have you ever listened to one?
Oh, yeah, I've watched them. I've watched some of the most most misguided, never asked the correct questions, just absolutely worthless forensic interviews I've ever seen, and think, well, the kid didn't say anything here, so we can't really say that anything happened. It's like, you never asked a single question. It was just, and it wasn't like slowly working into it and being good, with like a therapeutically getting into a subject. It was just shoddy work.
Oh, I've seen forensic interviews when I was a juvenile public defender. I saw one time that like literally the hairs on my arm stood up when I just talked about it. It like traumatized me beyond traumatized me. It's difficult for me to even like think about. But I think that could go back to there's just the Louisville component of doing things the way Louisville does it, which is probably, Louisville thinks a lot of times that they're like the best and the brightest of everything. I don't necessarily think that's the case.
It's funny. The interviews I've seen in Louisville have been good. The ones that I've seen from out of county were shocking, and I was measuring them against some of the ones that I saw that were done very well here. So that was just my experience.
That's funny. But there was notion too, it seemed the court ruling, and we'll move on. Sorry, we're talking a lot about this when there were so many cases that were interesting. But it seemed like the judge said, I'm going to give the forensic interview only to the FOC and no one else.
Yeah, that's what it was.
That's idiotic. Is there a better word?
Well, I just don't understand how it can be used. The friend of the court can't come in and give hearsay evidence. There's some case law where there are a few exceptions to that, but they're not going to be able to come in and talk about what a report says if the parties are barred from being able to review the report itself.
And even big picture, though, it's just like there are allegations a mother and father's child was abused, the mother and father have a right to see the recording of their child talking about their abuse.
Yeah, this is exactly facing your accusers, the constitutional right. But also as a practitioner, if the friend of the court was against my client and the weight of the evidence seemed to be against my client, I might want them to review that report so that when they're testifying, I can on cross-examination get them to admit that their opinion was formed based on a third-party statement that's inadmissible and is
High
inextricably
level.
yeah. Oh, I get it, but it just sets my point is it sets up so many problems if this case goes to trial. The admission of evidence and things, it just causes so many problems.
Yeah, idiotic. And also, most forensic evaluations, too, I don't want to say most, but a lot of times it could be the perpetrator could be not the mom or the dad. I mean, parents also the right to face the accused, but also parental, the constitutionally protected right to parent your child. You have a right to see that as a parent.
Yeah, but I mean, I just think, again, as an attorney, you're preparing for the report of a friend of the court. You're preparing the examination at trial of a friend of a court, but you don't get to see what, I mean.
It's insane.
And the rule says that they prepare a report 10 days before and have to give you full access to the materials they use to give that report. How does that jibe with an order that only the friend of the court gets to review certain evidence?
And I will tell you, I would say as far as being an expert on friend of the court, what they can or can't do, I practiced for 10 years, and Hugh literally knows everything. I feel like you should give like TED Talks on what a friend of the court is in Kentucky. No, seriously, because people don't follow the rules. And I don't think that attorneys know how to preserve the issues either, really.
Oh, I think the way that the system has been used, the way friend of the court has been used, I don't think there's anybody that can tell you what it is anymore.
Yeah. And if this is your first episode with us, very, very briefly, 2 types of attorneys, for children that are appointed by the court, GAL, guardian ad litem, that's actually the child's attorney, and then a friend of the court, like he was saying, doesn't have to be attorney, typically is, but is appointed to be a fact witness, an investigative body, right? Yeah. And so then we had in one, we were kind of chilling. We saw some people we knew, had a good vibe. Motion hours typically go an hour, but they're stacked in half hours. So we immediately bounced over to Shelly Santry in Division 2. I know you want to start with this one because that
was my biggest takeaway. This was the one that blew me away for the day. The fact that she was giving out hearing dates from the bench, and most judges, you go back and you talk to the staff to get a hearing date, and everyone else in the courtroom doesn't hear getting hearing dates. It just speeds things along. She was just giving out hearing dates to people while they were arguing the case, which gives us some insight into how quickly, how open her docket is and how quickly she can get people in. I was blown away. She was getting people in first week of September, and I think that she offered somebody some time that it opened up on August 25th.
So blown away, good or bad?
Oh, good. Phenomenal. So many divisions you go in, you would be 3-4 months out just to get a basic hearing. She was giving people half days in October, which is really short amount of time when you're requesting a half of a judge's day, when typically if they have district court dockets, different dockets 3 days a week, they only have 4 halves of days to get anything done. You're taking half of one of those to be able to get someone in October. That was mind-blowing. And my big takeaway is if they can do that in 2, why the hell can't we do that in other divisions?
Yeah, I feel like I looked over and your mouth was agape because it was like,
the first time she said September something, I was like, wait, what was that? Yeah. September?
And I did think it was really shocking, that division for me, for 2 reasons. I thought it was run really well. Yeah. I didn't necessarily, so what she does on her docket is she kind of does a first call, which is done in other states. So she kind of is if you have a quick thing, you could have your case called, and then she's going to handle all of the attorneys, and she's going to handle all of the pro ses, which I kind of like.
Yeah, and the way she described it and explained to the pro ses why they were last, and it didn't mean they were less important. She could give them more time. Yep. The attorneys can move on. I thought that was excellent.
Oh, that was a really good point. If you were in her courtroom and you had never been to court before, I think you would have understood the process immediately.
And you would have been so much less nervous and worried about it, given her demeanor and the way she handled it.
Yes. Now, the other side of it, just for me, is seeing what happens to a judge once they take the bench, in the sense of having known them before, right? Like Judge Santry I donated to her campaign. Y'all know I'm very vocal about the fact we should not be able to do that as lawyers, but I did endorse her. I did donate to her campaign. She dedicated her life basically to domestic violence, and the way the bench has sort of changed her in some ways is shocking to see. And I do have some sympathy for her. She looked dramatically different, just very, you could feel the stress. Could you not?
Yeah, I mean, I see that with most of them that are on the bench. I didn't know her well enough personally to really know. I mean, she certainly seemed different than when I used to practice against her a whole lot, but that was, when I actually think back, that was a long time ago. We probably all look very different. I just know that.
Oh, to me, it was like a dramatic shift. She's the first judge in Louisville Family Court that I knew as a litigator before that went on the bench. It was astonishingly dramatic.
Because she was actually a litigator before she went on the bench. That's pretty
that
rare.
That part, it's very rare. I was very disappointed in Shelly for not vocally coming out and saying, hey, Denise Brown, you shouldn't have selfie recorded the domestic violence hearing just because she dedicated her life to domestic violence. But you could just feel, it made me have sympathy for the judges. And I know to our listeners, but I did, because I could see the lack of joy and happiness that was like emulating from her. And I don't mean to say that to be mean. I'm not kidding. I'm like, literally, I had sympathy because she did seem a little bit like just I could feel the stress.
Yeah.
Is that wrong to say? I'm not trying to be mean in any way. I mean, she handled the docket very efficiently.
And it wasn't the only one that we felt that in.
Yeah.
Yeah.
The other thing, too, I loved how she handled the docket, but just for perspective of us not seeing what happens to pro se people, if pro se stuff is handled at the end, there's just no way lawyers would know. And I'm not saying it makes sense because lawyers are getting paid hourly. The judge is actually saving money to people that have attorneys. Like, I'm not criticizing her, but that could be one of the reasons why we don't know what's happening in cases involving two pro se people.
No, that's right. And that's what, I mean, it was interesting for me to see. And oftentimes when we've gone to motion hour, the latter division, some of the ones we've been to have taken long enough. We haven't gotten to the pro se cases because we've had to run to the next one. And judges get to attorney cases first so they can get to the next motion hour, and one judge isn't holding up everything happening in the other division. So it makes sense to do that. But also, they can spend the time necessary for the pro se cases. And I just, as a practitioner, I ran to the next division and didn't see those pro se cases very often. So it was interesting to see how each judge handled it, and I guess to a certain extent how differently it was handled between each division, although I didn't see a huge difference between the divisions that actually addressed pro se people specifically.
I would say 9 out of 10, though. Courtroom demeanor, courtroom control, courtroom respect. You knew you weren't going to get yelled at by her, but you also knew not to step out of line. I got that feeling, you know what I mean, with her.
Well, she's always been that way. Do you remember her as a litigator? She was tenacious and intimidating, but it was also always just very professional and friendly. She was one of the most fun people to have hearings with, and kept you on your toes. I always enjoyed practicing with her.
And then I think this is probably when it took a turn for the bad, as it started in 3.
The first 2, it was just like, wow, we're not going to get anything good out of this day. And then it just.
Oh, my word. I mean, we went into 3, and then packed house, louder, less courtroom control. Now, this is Lori Goodwin. Personally, I don't want to say, I probably do. I like her the best of all of them. As far as like personally, and just when she was at legal aid, she was fabulous to have a conversation with. She was always seemed to be like super prepared, knew the law. That was my experience with her. But this case, it just started to get out of control. And then we had the kid not in school.
Yeah. One of the things that stood out to me in the first time we sat through the latter divisions, where there were 2 big takeaways. One, the difference in, and we talked about it, the difference between, say, Division 8 and Division 9, like the docket control, the efficiency, the way you handle things. That was a big takeaway, but also certain judges now that it had been a couple months since I've seen them and see how stressed some of them looked. It was sort of similar here. There were 2 themes. One was the competency in the way you handled certain issues, or maybe it's not so much the competency, it's the authority, the way you acted as a judge. Okay, this is what's going on. I recognize it. And you have clarity as to either I can do something or we need to have a hearing so I can do something and then move on. It just started breaking down in 3. The other was, it was the demeanor and then the way that it sort of felt in the courtroom. And it just felt plausible, like very different, palpably different going from 2 to 3.
And so attorneys, we are used to, like, if we can get away with it, we will. And we're not saying,
yeah.
like, outside the bounds, but, like,
Oh, yeah.
to take it out of context, there was an attorney, there was a judge I used to practice in front of in Eastern Kentucky, like, literally the person that spoke last won. And so you would know, like, okay, I don't care. I'm just going to keep arguing my case. And then there was an attorney that was like, if you did that, they were going to be like, I've made my ruling. Like the management of what attorneys knew they could get away with. But when we got to Division 3, and it was also just the first case we walked in was an absolute shit show. We got a kid that like literally is not enrolled in school. It is August 18th. The judge is like, what do you mean the kid's not enrolled in school? And then you picked up on this. I missed it. There was a hearing in 2024.
I believe that's what they said. Now, I don't know if that's the one that's still outstanding, whether a ruling is still outstanding. It sounded like that's what was going on. In any event, this is under submission. The custodial, where the child's going to live, and therefore where the child is going to go to school is outstanding for the court to rule on.
Right.
And there's no answer. So the parties have just decided to play chicken.
Literally.
And the kid's just not in school. And the judge was shocked by it. But that happens all the time. Not necessarily children not being in school, but things that are normal. And you think, how in the world could this happen? Well, it's because they're waiting on you, Judge, to actually rule on a case that you've heard. Yeah.
And make a decision. And it's like, that's what was so amazing about Judge Santry is the fact that if you had an issue about holiday time, if you called me when I was practicing on August 18th and you're like, I don't have a parenting schedule for Christmas, it's like, well, nuts and bolts, because you screwed. You know what I mean? We're we're not going to get in front of a judge. Now, we can try to get an agreement between the parties and blah, 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 but like, you are not going to get in front of a judge. But then this case was just super bizarre because now the kid is 100% set up for failure because there was something about private school that the private school might not even accept the kid anymore. And then JCPS, the kid's going to be late getting enrolled, coming in. And the judge was just basically like, I'll get an order out, but the kid needs to be enrolled. It's like, okay, well, like.
Where?
Yeah.
Just give some guidance. You're the judge.
Or make a fucking decision.
Yeah, just do something. And so 3 was where that kind of started. And that got, that case was weird. There were allegations by one attorney that the other attorney was behind the kid not being in school and advising his client to do that. I wouldn't pay attention to that case, but it's the judge not controlling things and moving things forward and taking a position or doing something to solve the problem. Sort of began in 3, but it was just out of control in 4.
Yeah, I would say 1, 2, and 3, real quick. I would say the judges had read the motions that we saw, though, before court. I was really pleased by that. Like, they were, which, we shouldn't, that should be basic. But then we get to 4, and I'm telling y'all, wild, wild west. We had 3 cases on that involve Court of Appeals, at least 3 that we know of. But this is Judge Lauren Ogden. I don't even know where to begin.
Well, there are things you can do. You can set a hearing, control your docket, things you shouldn't be ruling on from the bench, get a hearing date, send them on. You don't need to let them just talk and talk and talk and talk. Or if there's something you can handle at motion hour, handle it. There were times where someone would suggest something or say, this is what should happen. And instead of having an opinion on it, she would turn to the other side and go, what do you think about that? What if you just did? And it was just like half-heartedly mediating the cases and never making a stand on anything.
Yeah, and then this is a Division 2 where it's like last one to talk because there was a case on and one of the attorneys was late, and this is nothing against the attorney. I think they were either may have been
still in 2.
Yeah.
In 3.
Yeah, but the judge basically was like, there's no way I'm putting this case on for at the end of August. And then once the attorney jumps on and they make their case, and she's like, well, I think I'm going to put it on for the August hearing.
Oh, yeah.
And you're like, as a judge, you should never, and I don't want judges to not admit when they're wrong.
It wasn't even the end of August. It was 7 days from yesterday, which means you've added an issue to a hearing. There will not be an order coming out that says 7 days before you have to exchange exhibits because there's no time.
Yeah. I'm a, criminals, how I was raised, I mean, we had very serious hearings in 7 days. I don't necessarily have a problem with the ruling in and of itself as far as big picture.
But you had rules that said you have a right to the evidence. As a defense attorney, you got what was there, what the prosecution had. You had a right to see it before you had a hearing on an issue specifically about it. Here you don't. The person didn't include the basis for the motion with the motion.
Allegedly. But my thing was just, though, as a judge, like, it's okay to admit when you're wrong, but you can do it in a way that's not for all of the crowd to see. I adamantly ruled A, and then someone else speaks, and I just completely 180 to B. And so then everyone watching is just like, oh, I can get her, No no courtroom management whatsoever.
I mean, I used to issue guidance for young associates or new associates at my firm and would talk about the tendencies of judges, and that was definitely in 4. Speak last. But, interestingly, just letting people argue and talk, and then the next person talk, and then they were talking over each other, and would sit there and listen to the arguments of them talking over each other and not control her courtroom.
Yeah.
But then there was an occasion where one attorney started talking and was explaining a motion. I guess, technically the other side wasn't there and she needed to call the case back when the other side got there. But she just right in the middle of his statement put him on mute and said, I just had to mute you because, and just
forgot about
muted his mic. I always got the impression that there just was never any courtroom control.
No. And you want to know what's interesting? We saw one attorney that had the exact same issue in Division 2 and in Division 4. Literally identical issue. The issue was a hair follicle drug screen. This attorney was saying it doesn't rise to the standard. This is an invasion of privacy. This is a violation of constitutional rights. Yep. And the way the attorney argued it in 2 compared to 4, it was so different because that's what is allowed and what works. Yep. And I mean, this attorney was about to lose it in 4. Like I'm talking about, was just trying to explain there was a frustration because I don't think the judge maybe fully understood the argument, which I don't know how you wouldn't. It's so basic. But it just really showed the difference in courtroom management, how the respect level that attorneys kind of have. And this attorney is very respectful in court. I'm not trying to say anything nefarious, but it was the exact same issue.
I mean, you could just... the frustration in the arguments. So the attorneys would make the arguments in some divisions, and you knew the time you had. You made the argument. The judge listened to it, allowed the other side, to respond. And if you needed to follow up, you asked, and the judge would let you respond, and then the judge would consider it and would say something, and the attorneys wouldn't be frustrated. If they lost, they would be, it was disappointing, and if it went against you, but it was just, that's the ruling. Yeah. They thought about it. They listened to the arguments. That's the way it's supposed to go. In 4, you could tell how just frustrated the attorneys were, and they just knew they could keep arguing and would keep arguing afterwards and just would argue with the judge, and she would engage in it instead of saying, I've made my ruling.
Get out.
You're done. Get out. It would just engage the parties in it.
I talked to an attorney afterwards that was like, I go to this motion every week just to watch the show. I
sat next to someone who came in and didn't have a case on, didn't argue anything, and then just left, and I'm just like, this is either their entertainment or I don't know, but it was something other than having a case on. And it really was fascinating watching. You went on to 5. I stayed in 4 just because it was like the accident you drive by and you just keep staring at it as you drive by.
Oh, you have. Okay. He says that about 4. Well, I left. I went on to 5. And it was probably 3 minutes in that I was texting you. And I was like, this is insanity.
Yeah.
This is absolute insanity. So then I go to Division 5. We are 11 o'clock, right? So we've been there for 2 hours, and it's so, you can just feel it percolating in the air, the chaos. It is just, but in Division 5, this is Judge Jessica Stone. She did not have any idea what the legal arguments that these attorneys were making. There was a case with 4 attorneys, all well-seasoned litigators from all different spectrums. And the one attorney finally just said, all right. And they were fighting about, it was a very contentious case from 2013. And there was talk about a therapist and reunification. And then one attorney who's probably been practicing 40 years, maybe 50, I don't know, was basically, all right, we're just going to take this really basic and start from the beginning. And then this other attorney who is known. What's the opposite of brevity?
Verbosity.
What is it?
Verbosity.
Verbosity. Okay, we're going to have a thing where Hugh teaches me, one, how to pronounce words, and two, how to use them appropriately.
I've just been accused of it quite a bit in my
What's
career.
it? One more time?
Verbosity.
Verbosity. Okay. This attorney literally said, Your Honor, I'm going to make this real simple for you. I think the exact opposite of what she just said.
I just think that is so brilliant. When you're in a situation where you're arguing something and the court is just not getting it, and you run the risk of, and the other side lays it out very simply, and you just don't want to muddy it. You just want to make it clear that the facts and the law, we see the exact opposite way.
Yeah.
It's just...
And then there were two other attorneys in, and it was shocking. And then all the lawyers are looking at me when they come back that are like diametrically opposed. And they're just like, what just happened? Also, this case, get back to our theme. So in 3, we heard something about waiving the Emberton rule. So then this case, one of the attorneys was like, I'm not waiving the Emberton rule because the FOC was on Zoom to make a recommendation. And I'm telling you, this case, you could tell just from the attorneys, they were all high-paid attorneys, 12 years of litigation. You got to think this is a 6-figure case on each side, right?
Oh, I don't know. I have no idea. They were acting as if it was, it sounds like.
I mean, 12 years, even if you're just at $10,000 a year for heavy litigation.
I would think the parties have easily cleared the 6-figure mark. I don't have any personal knowledge of it.
I don't even know what the other attorney was up there for. And all this attorney said was like, these kids are in real danger, like something along those lines. And the judge was just like, well, I'm going to take it under submission. And I don't even think it was something that you could have. I don't know. I got so confused. And then you popped over. But I will tell you, one, in Division 5, there's no case manager. No docket control whatsoever. Did you feel?
No. And I got the feeling in both 4 and 5, the demeanor from the court was just like, well, I don't know what I can do about that.
Okay.
And it's like, well, then who the hell can?
Right.
If anyone else could do anything about it, they wouldn't be in family court. This is a court of last resort, and you are it.
Yeah.
The buck stops with you. You are the only person that can do anything about this. How in the world can you sit there and say, well, I just really don't know what to do? And all but say that out to everyone who was just staring and thinking, what bizarre universe am I in?
And then there was a case on about, and this is where the judge really went on like this diatribe, and this is where it makes me think it comes just like straight from Mike O'Connell, because the whole notion of the name change thing, like making this a big to-do when in family court, a name change is like of no importance, right?
I don't know if I'd say that. I've had some serious fights over.
Okay, so no.
names.
I'm not talking about like as far as what your client thinks is important.
Oh,
I'm
you're
talking
about just getting it done.
Best interest of the child,
Oh, yeah.
like, or just like
absolutely.
safety of the child, danger of the child, like something that should be on your soapbox on as a judge. But she is requiring now for new petitions to be filed for a name change if there's a family court action, and for new service, which to me is just bizarre, because essentially if you have a custody case, if you get divorced in 2022, right, that case is like open. You can file motions in it forever and ever and ever and ever. And you don't have to, there are some circumstances, but if you file a motion in that within 6 months, you don't have to get new service, right?
Correct.
And she was saying for the name change you did. So you have to get new service to change a child's name, but not new service to suspend someone's parenting time?
Yeah, I mean, it's strange because there is a petition for name changes usually handled in probate court over in district court. And it required, a new filing fee, I don't know, maybe it's just about getting another filing fee, but in family court, it's regular that judges change kids' names. It happens in almost every single adoption.
Yep.
And they change adults' names all the time as well.
And it's legal standards, best interest, right?
Or consent if you're an adult. But yeah, we don't make adults, for instance, when you are going back to your maiden name, if you choose to do so at the end of a divorce.
Yeah.
if you were not going through a divorce proceeding, the way to do it was you go fill out that AOC form over in district court, and you would go through and file a new action, and there'd be service. Well, I don't know, there wouldn't be service in that case, but you would have to go through that. But you don't, because it's already within the jurisdiction of the family court. The court can actually do that. I don't know why you would need another one other than just another filing fee to the courts.
Yep, and I think that was 100% a talking point or something that was fed to her by either, somebody on the clerk side or somebody else, because I don't think that the thought was original. It could be, and I'm not trying to be disparaging, but I'll tell you,
It really sounded like, okay, here's how we've been told we have to do it now.
And not by no other court's doing it. It's just Division 5, who literally has no family court experience whatsoever.
Well,
None.
I don't know. Did we see that issue in other courts? Do we know that they're not doing it?
The verbiage that she spoke about was like, no, that's not how. It was very much like, this is just my court. That's how I took it. If I'm wrong, I will apologize. But I think it's something that only someone that only practiced in district court would ever think is important personally. Like, it's just like, bless your heart, you know what I mean? You ain't in Kansas anymore. But I have serious concerns about Division 5, Like, there was more enthusiasm and attempted knowledge, or the thought that the judge had knowledge about this name change, than there was about the case with a child that was seriously endangered. Seriously.
Yeah. I mean, and what
Allegedly.
was really remarkable is attorneys that just we know personally aren't necessarily fans of one another, that just, you see them walking up on a case and everybody just shuts up and watches because there's going to be fireworks.
Yeah.
You would see their collective experiences when they turned around to walk back from the bench. They would be on the same side, just like, oh, good Lord, what did we just encounter? They had just gone through something together, and they weren't fighting anymore because they were both just ran into the same brick wall.
It was like bonding, and they were looking to both you and I, like, just for help. And even attorneys that don't necessarily love you or me, they're just like, oh my gosh, because it's just hard to explain, like, how the lack of understanding of just basic procedure and legal.
I remember doing that. I remember being in motion hour and just thinking, I would come in, I would expect that this is going to happen, this is going to be the result, and then it would be the exact opposite. Yeah. And I would turn around and I would look for someone in the crowd to sort of look to see what their expression is.
Like, help me.
Yeah, well, or not necessarily that. It would just be like, am I wrong, or was that really bizarre? You could tell from their expression. They would communicate back to you just like, oh, damn, I didn't see that coming. And you would realize, okay, I'm not crazy. And so we saw a lot of that.
That's so funny. And we went on our little tangent. We could break down all of these and I could just in real time, like, follow court. We're going to get the tapes, so then we can start doing breakdowns of that. We have a plan. We know y'all love the breakdowns of what's actually happening day to day. I think that's about a wrap for today. I do want, I guess, real quick, your rose and thorn of the day, like your highlight and your low.
Oh, the highlight was the docket control in the first couple of divisions, especially Division 2. That made me very hopeful that there is a way to manage the amount of cases that are coming through the family courts and still get people in and out and make decisions that keep families from going through the process for years at a time.
I would say my high too was probably Angela Johnson, really, and Shelly. I thought, it was a little different just like because of the sad factor a little bit, or sympathy factor. But both of them, I was, really impressed with how they handled it. Do you have a low?
I don't even know where to start. It just
30 seconds or less.
4 and 5, just seeing how the courts just can't act as judges with any kind of authority or any kind. I mean, if you cannot be decisive and actually be the one to determine what happens, what are you doing on the bench?
Yeah, I'm split too with 4 and 5. I would say the thing about 4 is that she's going to get it wrong, or if she's overturned by the Court of Appeals, she's going to fight tooth and nail to keep doing it her way and not the way that's ordered by the law. In 5, I have a legitimate fear that something bad is going to happen, because I even think in 4, if there are really serious allegations or something, then there is that little bit of a flip with Ogden to take it more seriously. But in 5, I am terrified that something bad's going to happen.
That's an awful thought.
Yeah, and I don't say that lightly. But to wrap up housekeeping stuff, submit your stories to judge-y.com. If you send stuff to me at Kentucky Christine, I have no problem. I love hearing from y'all. I cannot respond to everybody. I'm getting so much, but it doesn't go into queue, so there's no guarantee that it's getting investigated or being properly allocated. I'm getting hundreds and hundreds of messages. So Judging the Judges on Instagram, judge-y.com, Judgy on YouTube, and there's another social media platform I'm forgetting, TikTok. You got any housekeeping stuff?
I don't.
Awesome. See y'all soon.
See ya.
We need some justice, justice. My life is fine, justice.